A very good afternoon to all of you. Mr. Dushyant Dave, President of the SCBA, and the other office bearers, Mrs. Yu Singh, the Chairperson of the Organizing Committee, Learned Attorney General, learned Senior Advocates, members of the bar, and dear students. Democracy and dissent. This was the topic, but the outset I may say that I have also added dissent in decision-making process in the judiciary, because I thought that is also very essential, because one of the core aspects of democracy is judiciary, and we have to have a fearless judiciary if we have to have a democracy. I've been in the profession for 42 years, much less than the Attorney General, but much more than many of you here. And out of these 42 years, for 26 I've been a lawyer, so I still think I'm 66% a lawyer. And sometimes you see it when I argue with you in court. What I've really missed in the 16, 17 years on the bench is the bar room. What happens in the bar room can never happen in any other place. About 3-4 months after I take an oath as judge, I went to my Chief Justice and said, I'm having second thoughts, I feel like resigning. He said, what's happened? I said, I miss the bar room. So that was the level that because you feel very isolated in your chambers, especially when you're a junior judge and can't even walk into a senior judge's chambers without an appointment, so to say. Coming back to the topic, I mean, talking about dissent to the bar is like taking coals to Newcastle. The bar is that most unholy of places where nothing is sacred, where no reputation is so unimpeachable that it cannot be blown to smithereens, no personality so towering that it cannot be brought crashing down, no character so pure that it cannot be torn to shreds. We do everything in the bar. There's no idea so holy, so sacred that it cannot be challenged. And we have arguments, heated arguments, sometimes aggressive arguments, but by and large they always end up with a shared cup of coffee or tea. And that is the beauty of a dissent, which is on ideas and not based on power or anything else. When it's a clash of ideas, there has to be a dissent. When I talk of dissent in democracy, I think this most beautiful of books which we have, the Constitution of India, I always refer back to it. And the preamble has adorned my table in the chambers the day since I became a judge. And anytime I feel difficulty in finding a solution to a problem, I read the preamble again, and I, more often than not, find the answer to my solution to my problem. And what have we promised to ourselves? Liberty of thought, expression, belief, faith and worship. I'll leave aside faith and worship for the time being more religious in nature. But liberty of thought, expression and belief. Because a belief can be an agnostic belief, it can be an atheist belief also. Now read it in conjunction with the first 3 clauses of Article 19, which all citizens shall have the right to freedom of speech and expression, to assemble peaceably and without arms, to form associations or unions. When you read all this together, what does this Constitution guarantee? It guarantees to you, which for me is the most important right under the Constitution, not clearly written down, but the right to dissent. This, like the right to privacy, which has been read in the Puttaswamy case as evolving out of the other rights, is also the right to dissent, the right to disagree, the right to have another point of view, inheres in every individual, not only because of the Constitution, but because it is a human right to disagree. As Mr. Arora said, and I had this in my part of my speech also, that those of us who are married know very well what dissent is. We more often than not are on the losing side, but we still welcome dissent. Any decision in a family also has to be decision, informed decision of the entire family. We can't have the decision of the patriarch taking place in today's world. So it has to be an informed decision, and more often than not, unlike what Mr. Arora said, the children will tell you that you don't know anything. We know what we can do and what we will do in life, and they have been right. At least in far as my children are concerned, the decision they have taken have proved to be right. So the right to dissent, the right to disagree, forms part of any human being's rights. But I chose this topic when very many topics were given to me because of what is happening and what is troubling us in the country today, where dissent is termed to be something like as if you're an anti-national or a traitor to the country. Just because you hold a contrarian view does not mean that you are disrespectful to the country. You may be disrespectful to the government or the powers that be, but the government and the country are two different things. But more why I'm troubled is because I see members of the bar in various parts of the country, thankfully not the SCBA, but various parts of the country, bar associations passing resolutions that in such and such matter they will not appear because it is an anti-national. I'm sorry, that goes against the provisions of the Advocates Act. It goes against the provisions of the Bar Council rules and the rules which basically as advocates, we cannot refuse to give legal aid to anybody. And then when bar associations passed this, so I thought I'd take this opportunity of sending a message to the bar associations in the country that this is not done. It was the members of the bar who were in the forefront of the freedom movement, the civil rights movements. They've led all sorts of movement. And at this stage to say that we will not even appear for somebody charged of certain offences is totally unacceptable. This is, in fact, amounts to an obstruction of the judicial delivery system. We've talked about dissent as constitutionally there, also as dissent as a human right. But dissent is the very basis of a society. See, when we travel from a totally, say, 5,000 years back from a very agrarian, rural society in the Stone Age, developing further, each society has its own rules, and over a period of time, those rules become the laws of that society. And that society will not develop if somebody does not question the rules. That society will become a stagnant society if nobody challenges what are the accepted norms. If we all follow the well-trodden path and refuse to think beyond, there will be no expansion in the vistas of the mind as we progress further. If we do not ask questions and do not challenge age-old customs, there would be no new thought. Whether it be Buddha, the Mahavir, Jesus Christ, Prophet Muhammad, Guru Nanak Dev, Martin Luther King, Kabir, Raja Ram Mohan Roy, Swami Dayanand Saraswati, Karl Marx or Mahatma Gandhi. They all challenged accepted norms. And it is only because they challenged accepted norms that new thought came in. We may or may not agree with the thought, but new thought will only come in if you challenge old thoughts. And therefore, it is very necessary that the right to question, the right to dissent, is not only an inherent part of a democracy, but inherent part of the right to life itself. As far as democracy is concerned, if a country has to grow holistically in a manner, not only talking about economic rights or military might or anything, where civil rights of the citizens are protected, then there has to be a very important role for dissent. In fact, dissent must be encouraged, because if it is only through discussion, disagreement and dialogue that we can strive for finding better ways to run the country. See, this recent past, there has been some unfortunate instance when any dissent, anything, slap a case or term them anti-nationals. And I can't do better than quote from what Brother Chandrachud said recently about a week back in the Justice P.D. Desai Memorial Lecture. Incidentally, few months back, I was there in the valedictories of the P.D. Desai, who I, without any reservation, say was the finest judge I have ever known in the country, ever. The blanket, and I quote from what Justice Chandrachud said, the blanket labeling of dissent as anti-national or anti-democratic strikes at the heart of our commitment to protect constitutional values and the promotion of deliberative democracy, unquote. I don't think I can put it in better words. What is the essence of a democracy? That every person has a right to elect the government. So the government is elected by, well, a majority vote. But though rule of majority is an integral part of democracy, in my view, majoritarianism is an antithesis of democracy. Especially in a country like India, where our democracy is based on the first past the post system, more often than not, those in power will not represent the majority of the voting electorate, let alone the majority of the people. But let us assume that they have got 51% votes from the population-wise. Does that mean that the other 49% now have to keep silent for 5 years and say nothing? Does that mean that those 49% have no voice for the 5 years? That they must accept whatever is done and not protest against it? So in a democracy, the government once elected is a government for the 100%. It's not a government for those 51% or whatever percentage voted for them. It's a government for all the percent. So every citizen, whether he voted for you or did not vote for you, has a right to play his role in the democratic process. The right to dissent, I mean, it can't be repeated more often, is one of the most important rights in a democracy. So long as a person does not break the law, encourage strife, or encourage violence, or secession, etc., he has a right to differ from every other citizen and those in power and propagate what he believes is his belief. This brings us to the role of the superior courts, who, as protectors of the rights of the people, have a duty to ensure that the powers that be do not suppress dissent or quell dissent. I again will quote from Brother Rohinton Nariman's small passage from Shreya Singh's case, where he talks about the chilling effect of censorship or something of this nature in point of law while dealing with Section 66A of the Information Technology Act. In point of fact, and I quote, in point of fact, Section 66A is cast so widely that virtually any opinion on any subject would be covered by it, as any serious opinion dissenting with the mores of day would be caught within its net. Such is the reach of the section, and if it is to withstand the test of constitutionality, the chilling effect on free speech would be total. So if we quell dissent, if we discourage dissent, it has a chilling effect on free speech. The very essence of democracy is that every citizen has a right to participate not only in the electoral process, but also in the way in which our country is run. This right becomes meaningless if that person cannot criticize the actions of the government. The citizen is not only a participant in the democratic process, he is an integral part of the country and has a right to express his views, even if they be totally contrary to the views of those in power. No doubt these views must be expressed in a peaceful manner, but citizens have a right to get together and protest when they feel that actions taken by the government are not proper. Their cause may not always be just. They may be pursuing a cause which is not actually right, but then governments are not always right. So we all commit mistakes. Merely because certain groups oppose those in power cannot take away the right to oppose what is proposed by the government or to oppose any actions of the government as long as the protest is peaceful and non-violent. The governments have no right to stifle or quell protests as long as they do not breach the law. Expressing of dissent by means of protest is the legacy left behind by Mahatma Gandhi, the father of the nation, in the form of his civil disobedience movement of Satyagraha, following the path of Ahimsa. So if that is there, there can be no disagreement with that form of dissent. Since a lot had been said on the importance of dissent, especially in Justice Chandrachud's speech recently, and my views are almost very similar to his on that matter, I thought that since time is at hand, I will break up my lecture into the second part, where I talk of the importance of dissent in the decision-making process in the judiciary. Before I talk of the dissenting judgments, one thing I would like to talk about is, in the earlier part of the lecture, I said that the bar associations are the most unholy of places, but they are a shrine to one concept, and they are a shrine to the concept of the rule of law. I think nobody who belongs to the judicial fraternity can deny the importance of the rule of law. And what is the rule of law? The rule of law as a principle of governance, like democracy and the separation of powers, is an integral part of our body politic. It is the golden thread which runs through our constitution. Anywhere, anytime, when ordinary people are given the choice to choose, the choice is the same. Freedom, not tyranny. Democracy, not dictatorship. The rule of law and not the rule of men. The bedrock of our democracy is the rule of law, and this necessitates that we must have an independent, fearless judiciary. There can be no rule of law without a judiciary which is fearless and independent. We can have a rule of law when we have judges who can take decisions independent of political influence, totally uninfluenced by the media or any other extraneous considerations. A free country is one where there is freedom of expression and governance by the rule of law. When there is no sharing of power, no rule of law, no accountability, there is abuse, corruption, subjugation, and indignation. When the rule of law disappears, we are ruled by the idiosyncrasies and whims of a few. Therefore, why I am interwoven this is that rule of law is as important a part of democracy like dissent. And then judges who interpret the law, if they strongly feel that this is an issue on which they have to dissent, they should not be scared to put forth their views in a dissenting judgment. True it is that in any jurisprudence, we like to have a constant law, not changing every day, otherwise that leads to its whole problems. If every day the interpretation of the law keeps changing, then there's no certainty of the law, which is also not desirable. But in this fast-changing world, the views on any subject cannot remain constant. The meaning of every word in the Constitution, the meaning of each word in any statute, sometimes has to be given a different meaning, a changed meaning as times progress. You can't keep amending the statute or the Constitution every time. Otherwise, it would be something like Nepal. They have the 8th or 9th Constitution now. That is not proper. We should have to have, the development, a more dynamic interpretation to the Constitution as well as the statutes to make it ensure that they are made workable given the circumstances. As pointed out by Mr. Arora in his opening remarks, but we must know when to dissent. Dissent just for the sake of writing another opinion is meaningless. Dissent just for the sake of dissenting is also not correct. Because judicial importance is probably as important, if not more important, judicial discipline is more important than the right to dissent in every matter. You see, when I sit as a judge, there are so many three-judge decisions or five judges decisions, which I may feel may not have laid down the correct law. But that is my feeling as Deepak Gupta. When I sit on a two-judge bench or a three-judge bench, I'm bound by the judgment, and that is how it should be. Not every case should be referred at the drop of a hat that I take a different view, so send it to five judges or seven judges. I think the law on this regard is very clear. But when you have to dissent, when important issues are involved, then even if you have to take that step all alone by yourself, that should not come in the way of the judge of dissenting. And I'm not too good at Bangla, so I will not attempt to read the original, but only quote from Tagore's Ekla Chalo Re, that open thy mind and walk alone. If you are even if you are all alone and nobody joins you, you must walk alone. Because that is, if we have to be true to our oath, then even if we have to walk alone, we should not hesitate to so. Dissent is a very powerful tool in the hands of judges, but it has to be used with great responsibility and restraint. There's no idea of dissenting only to manufacture a dissenting judgment. But a good dissent sows the seed which develop a new thought and which may at a later stage develop into a totally new approach to law. Before I talked of the various dissenting judgments which I have referred to, there are two from the US, one from UK, and a few from India. The first is Plessy versus Ferguson. This was where a challenge was made to the slave trade and whether these, unfortunately, I am using the term, a term which should not be used now, but since it is in the judgment, is whether Negroes could be called citizens of the country. Now that, by a majority of 7-1, they held that they have no right to be called citizens. The 1856 in the first judgment. The dissenting judgment, Justice Marshall said, in the eyes of law, there is in this country no superior, dominant, ruling class of citizens. There is no caste here. Our constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law, unquote. Now, that is in the context of a constitution. Please remember, it is more than 150 years back, when societal norms were totally against what this judgment had written. And later this judgment became the law of the land. Again, they began in Brown versus Board of School Education. Then there's a famous Dred Scott case of 1896, where a slave who had lived in some free territories of the US came back to a territory which had slavery as legalized and said that he was a free man. But again, by majority, it was said a Negro whose ancestors were imported into and sold as slaves cannot claim any rights. So, first was where they had different, segregation by way of separate compartments in trains. And the second was when they were slaves. But still, in both these cases, later the Supreme Court of England took a different, the United States Supreme Court took a different view. But one of the finest dissents ever is of Lord Atkin in Liversedge versus Anderson. And one must remember, this happened in 1941, when the Second World War was at its highest, when the Blitzkrieg was having its effect in London day in and day out. They were being bombarded night and day. And the question arose about the liberty of a person whose loyalty to England was highly questionable. And Lord Liversedge said, in England, amidst the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war and in peace. It has always been one of the pillars of freedom, one of the principles of liberty, for which on recent authority we are now fighting, that the judges are no respecters of persons and stand between the subject and any attempted encroachment on his liberty by the executive, alert to see that any coercive action is justified by law. But for me, not only is Dissent very important, but also the way he said why he dissents. And again I quote Lord Atkin, quote, "I protest, even if I do it alone, against a strained construction put on words with the effect of giving an uncontrolled power of imprisonment to the minister." Unquote. So this was his view. As such, coming back home, Gopalan is the first case where the dissent of Justice Fazal Ali was remarkable for the time. We must remember that this was a time we had just become independent, the constitution was new, and the Supreme Court reposed a great deal of confidence in the government when it felt that the executive would not go against the people. The majority opinion in the case of preventive detention was that if, taking a very literal view of Article 21 of the procedure established by law, that once the procedure is laid down by the law, you can't question it. Justice Fazal Ali said that, though not in so many terms, but the gist of his judgment was that even the procedure established must be a fair procedure to be in and should be in line with Article 14 of the Constitution. This judgment, to those of you who have joined profession in the last 15-20 years, would seem so unremarkable. Well, you would feel this is understood always. But please remember, at the time when it was given in 51, it was a path-breaking judgment. And finally, this was accepted to be the correct view in the back nationalized case in R.C. Cooper. The second important dissent was in Khadak Singh case, Justice Subbaro's dissent, where the question was whether the right to privacy is a fundamental right. Now we all know that now it has been held to be a fundamental right, but that is many years later. But what he said is almost as if he sort of understood what a judgment is going to be given half a century later. And I quote from Justice Subbaro's judgment, quote, "As already pointed out, the right of privacy is not guaranteed right under our constitution, and therefore the attempt to ascertain the movements," no, this was the majority, sorry, and this is the majority, "and the attempt to ascertain the movements of an individual, which is merely a manner in which privacy is invaded, is not infringement of a fundamental right guaranteed in Part 3. But then Justice Subbaraw held, "It is true that a constitution does not expressly declare a right to privacy as a fundamental right, but the said right is an essential ingredient of personal liberty." Again, a judgment way ahead of his time, like many of other judgments of Justice Subbaraw. I will be talking about the third very important judgment later on, but I want to deal with a few other dissents which I feel are very important. In the Sridhar Mirajkar case, where the older generation would know this, where there was this litigation against Mr. R.K. Karanjia, the editor of the Blitz, for defamation, and Justice Tarkunde passed an order that the proceedings of the court would not be reported. That order was challenged. And the issue that arose was whether the order passed by a judge or whether the judge is also susceptible to the writ jurisdiction and whether he is also bound by Article 14 of the Constitution. The majority held that the order was proper and the decision of a judge could not be subject matter of such a decision. But Justice Hidayatullah held, these provisions show that it cannot be claimed as a general proposition that no action of a judge can ever be questioned on the ground of breach of fundamental rights. The judge no doubt functions most of the time to decide controversies between the parties, in which controversies the judge does not figure, but occasion may arise collaterally where the matter may be between the judge and the fundamental rights of any person by reason of the judge's decision. It is true that judges are the upholders of the Constitution and the laws, are least likely to err, but the possibility of their acting contrary to the Constitution cannot be completely excluded. Unquote. This judgment is still a minority judgment, though orders have been challenged. But this is another judgment which raises a very, very important issue, which maybe time will tell whether it will change or not. Then Justice Sinha's judgment in ZJ Telefilms case, where he held that BCCI was state within the meaning of Article 12. Yeah. So that is another very important dissent according to me, which though in the later two-judge bench it was said that though it's another way of to go around it was found, that they're doing some public function, so they are amenable to writ jurisdiction. But the question whether such bodies are state within the meaning of Article 12 may sometimes be taken up again. Two recent dissents, one by Justice Chandrachud in the Aadhaar case and one by Justice Indu Malhotra in the Sabrimala case, are two very, very important dissents. But since they are both subject matters of judicial scrutiny, I won't say anything further than saying that these are very important dissents. That brings me to that greatest of dissents this country has known. The dissent by Justice H.R. Khanna in the ADM Shukla case. Again, before reading this dissenting judgment, one must go into the background. The emergency is on. 9 high courts have had the courage to hold that such laws, that fundamental rights exist even during the emergency. And he is in line to be the next Chief Justice of India and knows, given the recent past history of 1973, that if he opposes the government, he is likely to lose his post. He still gave the dissent. And it is said that he told his sister one day before the judgment was pronounced that I have dictated a judgment and now I will not be Chief Justice of India. But anyway, he will not be, he says, meri naukari gayi. So, he knew that he was putting his future as Chief Justice of India at stake. Knowing the past history when 3 senior judges had been overlooked when Justice A.N. Ray was appointed Chief Justice. That did not deter him in doing his duty and delivering a judgment which even today has been acknowledged to be the correct position of law. I would like to quote a few lines, a few paragraphs from this judgment. First, on what he said about preventive detention and the rights. I quote, "Law of preventive detention, of detention without trial, is an anathema to all those who love personal liberty. Such a law makes deep inroads into basic human problems which we all cherish and which occupy prime position among the higher values of life. It is therefore not surprising that those who have an abiding faith in the rule of law and sanctity of personal liberty do not easily reconcile themselves with a law under which persons can be detained for long periods without trial." The other part of the judgment which I feel is very important is where again, like Lord Atkin, he again gives reasons why he is willing to dissent all alone. "Before I part, and I quote, before I part with the case, I may observe that the consciousness that the view expressed by me is at variance with that of the majority of my learned brethren has not stood in the way of my expressing the same. I am aware of the desirability of unanimity if possible. Unanimity obtained without sacrifice of conviction commends the decision to public confidence. Unanimity which is merely formal and which is recorded at the expense of strong conflicting views is not desirable in the court of last resort. Then he quotes from, Justice Khanna quotes from Chief Justice Hughes and says, a dissent in a court of last resort, to use his words, is an appeal to the brooding spirit of law, to the intelligence of a future day when a later decision may possibly correct the error into which the dissenting judge believes the court to have been betrayed. Unquote. This is the power of dissent, both in democracy as well as in the judiciary. The right to dissent, to conclude, includes the right to criticize. We all must be open to criticism. The judiciary is not above criticism. If judges of the superior courts were to take note of all contemptuous communications received by them, we would only be doing contempt work in court. At least I get 50 letters a day which are highly contemptuous. Not to me, but somebody or the other. Sometimes to me also. Criticism is always welcome. Introspection should also be done regularly. Are we moving around the right path? Criticism of any institution, whether it be the judiciary, the bureaucracy, the executive, the legislature, or the armed forces, cannot be termed as anti-national. There is no holy cow as far as dissent is concerned. In case we attempt to stifle criticism of the institutions, whether it be the legislature, the executive, or the judiciary, or other bodies of the state, we shall become a police state, which I am sure our founding fathers didn't want us to be. To question, to challenge, to verify, to ask for accountability from the government is the right of every citizen under the Constitution. These rights should never be taken away, otherwise we will become an unquestioning, moribund society which will not be able to develop any further. I can end only with my favorite poem of Guru Rabindranath Tagore, which has adorned my office since I became a lawyer, since I intend. But before that, I just want to add two more lines. I said that Justice Desai was one of the finest judge I have ever known. Because there are many who may not have even heard of him. He became a judge at the age of 39. In 83, when he was hardly 44 years old, he became a Chief Justice of my court, Himachal. He was our Chief Justice for 5 years. For 2.5 years, he was Chief Justice of Calcutta. Another 2.5 years, he was Chief Justice of Bombay High Court. For 11 years, he was Chief Justice and one of the finest Chief Justices anywhere in any of these courts also. And later refused to come to the court for any reason. That's not the issue. But as I said in Ahmedabad about 6 months back, he did the right things. He did not play the cards right. So I end up with that great poem of Rabindranath Tagore, which is a tribute in a way to dissent, where the mind is without fear and the head is held high, where knowledge is free, where the world has not been broken up into fragments by narrow domestic walls, where words come out from the depth of truth, where tireless striving stretches its arms towards perfection, where the clear stream of reason has not lost its way into the dreary desert's sand of dead habit, where the mind is led forward by thee into ever-widening thought and action, into that heaven of freedom, my Father, let my country awake. Thank you. Jai Hind.